Warning, you are about to listen to the greatest radio show ever. And due to contractual obligations and to shield our airwaves and corporate licensees from any semblance of liability, responsibility, and gullibility, we must tell you the views represented on this show are not necessarily those of this station or its management. This radio show contains differing points of view on current political topics, and due to the nature of its contents, it should be heard by everyone. Thank you for listening.
3, 2, 1.
Now live from the Devil Radio Studios in Madison, Wisconsin, where the political party is just beginning. Welcome to the Devil's Advocate Show. Friends proving it's never personal, only politics.
Please allow me to introduce myself.
Here is your host, Mike Crute.
Welcome back to the Devil's Advocates Radio Show, the Thursday, Friday Eve edition, a happier happy hour. Dom gets happier right now. We got a fine guest joining live via video. He is former U.S. Attorney James Santelle. He is host of the Morning Cannoli on the Saturday morning. And Jim, just for the record, counselor, is it cannoli or cannolis?
You know, we have to figure this linguistic question out, but we will do that maybe after we solve some other problems in the state of Wisconsin and our United States of America. But it's on the list. It is on the list, I assure you.
Jim, so very nice to have seen you. I think it was Tuesday
Yes.
night at a Blue Sky Waukesha event. You graciously spoke and then gave me a little introduction. I got to tell you, Jim, you called me your boss, and I almost did a spit take. More humorous words have never been uttered, Jim. Hardly, but we do appreciate you coming round, counselor.
We're always after the laughter, right? So pursuing that on Tuesday. Good to see you also, Mike, and a good community event as well.
It was well attended and good victuals and nice house and all that kind of stuff. Jim, the former president of the United States, in the midst of a fraud trial, and I thought he was under gag, and now I understand maybe an appellate court has removed the gag, so he's back out posting, according to thehill.com. Here is what he's saying at the last. Why doesn't the implosion of the AG of New York's star witness in this witch hunt, and I think he's referring to the Michael Cohen testimony, right? He admitted on the stand that he lied and that I never told him, and this part's all caps, Jim, I never told him or anyone else to inflate the numbers. And then he goes on, in fact, the numbers are low or very conservative, the exact opposite of what this ridiculous rigged case is all about. The fraud by the judge and the AG, Mar-a-Lago, and more. The former president added, not by me. So, Jim, should he or shouldn't he be trash talking on the Truthy Social today?
He should not be. Again, what's happening here, of course, is that Judge Engeron, who is the New York judge who's presiding over this, has said that he is prohibited from engaging in this kind of conduct when it comes to court staff, certainly identifying his own clerk, which was a problem in the past, and also talking generally about witnesses, other things related to the trial. The rule on this generally is you're not stopping him from maintaining that he is innocent. If he wants to do that, he can complain about the fact as he believes that the complaint, the civil complaint, was improperly brought, even go so far as to say there's not sufficient evidence. But when it comes to doing more broad things like this, including the things that he has said in the other trials as well, he's also getting in trouble, as we know, with Judge Tanya Chutkan in Washington, D.C. That matter also the subject of a so-called restrictive or gag order there. He shouldn't be out there doing this because the general principle is what you're doing is you're affecting obviously the rule of law. For those cases that have not yet gone ahead to trial, you're potentially impacting the witnesses. You're potentially impacting the jury pool, which is a real concern when it comes to that Washington, D.C. case as well. All this has been much bandied about and argument in front of the judges. And again, no other defendant, no other criminal defendant, no other civil defendant would be permitted to do this. He has been given an awful lot of rope, if you will, a lot of length here to go down this road because I think judges are aware of the fact he's running for the presidency and has this bully pulpit out there. Even so, as Judge Chutkan has said, should be treated like any other defendant in her court. In this court in New York, shouldn't be doing this at all.
Jim, over 200 defense witnesses could be called. I mean, I'm sort of losing track of who's giving testimony next and why, but I know the defense led with Donald Trump Jr., and he had already been compelled to give some testimony before the judge, under question by the AG's team. Do you think he accomplished anything from the reporting we've seen from the courtroom? Did he make any ground up? Did he create any more solid ground on which to stand?
It certainly didn't seem that way. Again, it seemed to me, and I think to many people, that his principal purpose up there was to tell everyone how wonderful his father is. Talked about how he's a genius, how these structures are absolutely magnificent. Mar-a-Lago's one of the great constructs in American architecture, all that kind of
The
thing.
Louvre of
Yes,
construction.
exactly, right. And that may be interesting. I think it also wears on the judge also. Not relevant how one independently, personally feels about the grandiosity of a particular piece of real estate. The question, once again, is knowing that there's already been fraud. There's been a finding of fraud already made by the judge. What was the intent of the players, including Donald Trump Jr., his brother Eric, and yes, Donald Trump himself, other players in that, and then not only tying that intent to this conduct of fraud, but also figuring out, as we're now in the midst of, figuring out how much money the state of New York should get as a result of this. We now have these series of financial folks, these bankers coming in, talking about their relationship with Donald Trump. Well, I think the significant takeaway in the defense case now underway is they're staying far away from the documents themselves. This is a documents case, and Donald Trump, I think, has already been convicted civilly, if you will, for engaging in the fraud that Judge Engoron found. Also, those documents speak to intent, speak to the level of fraud conducted here. The attorneys are wisely trying to put that behind them and instead talk about these larger issues about the fact that there was no intent here. Oh, and by the way, it was the bankers who did this. They should have done their due diligence. The lawyers were the ones who were responsible for this, as the sons have said, diverting attention and focusing on other things other than the factual findings made by the judge already, and trying, I think unsuccessfully, to break that tie between the fraud and their own involvement in it.
Folks, you're listening to the Devil's Advocate. James Santelle, former U.S. Attorney, host of Morning Cannoli here on the network Saturdays at 9 to 11 a.m. Jim, always a pleasure to talk to you, man. The Georgia case, proffer videos released. One of the RICO defendants' attorneys released the videos of Jenna Ellis and the Kraken lady and Cheese Bro. And I want to get your sense, number one, and Fannie Willis is asking for a protective order. I believe she got it to limit these things from happening again. Number one, based on the content of those videos, Jim, how's it looking for Donald Trump from your opinion?
It's not looking. There are variations. I think Jenna Ellis perhaps taking a role as a cooperative a bit more serious than Sidney Powell, maybe, for example. Scott Hall, who is this bail bondsman, also testifying. Ken Chesbrough, not quite as compelling, trying to maybe minimize his own involvement, maybe throwing a few bones to Donald Trump. But they're all plainly cooperating. They're providing statements, and they know now that if they engage in knowingly false representations about what happened, they're going to be in trouble. The significant issue here, Dom, is just as you described it. Let's name the lawyer. His name is Jonathan Miller. In my profession, not at all pleased by this. He's representing this Coffee County elections supervisor named Misty Hampton. She's among the remaining 15 defendants in this case. And he says stunningly that, the things that I released, they were helpful. They did not, I don't believe that those hurt my client. If anything, I believe they helped my client. The public needs to know what is in these tapes. Well, the answer is just the opposite. And that's why Fannie Willis has responded. And the judge has also responded by establishing, again, Scott McAfee is his name, establishing one of these orders that says, you know what, you can't be doing this. You can't be releasing what is basically provided to the defense as discovery. And again, to follow up on Mike's good question at the top of the segment here, what is the norm here? What happens is that prosecutors in criminal cases, civil cases as well, but especially criminal cases, provide all of the evidence to the defendant. And that's what Fonnie Willis has done. And I'm producing these additional tapes that are a part of the cooperating witnesses here, and producing that so that there is fairness in the process. It is not intended for public release. That's not the purpose behind it. I will tell you, if this had happened again in federal court in my former practice and other settings here, there would be a whole lot of trouble going on here. And the fact that the attorney says, well, I'm doing this because the public has a right to know. The public has a right to a fair and just trial. That is not enhancing this. And again, you have to believe that he's doing it not to establish something on behalf of his client, or maybe only indirectly, but really leading into that and supporting that notion. You got to kind of provide some information to the public, to the base that's out there for Donald Trump and other people, showing that these folks are cooperating. And arguably, once again, getting back to the issue that Mike asked before as well, arguably encouraging some threats and some direction toward them. If people see that these folks are cooperating and they're huge Trump supporters, that's the kind of thing that you're afraid of. Once again, this is bad from start to finish. Good for Judge McAfee to say no more. It should have been in place before. And frankly, this attorney knew better. There may be other attorneys. There's some inkling that there are others out there also provided these materials to other outlets out there. All of them should be chastised. And the fact that there was an order imposed later after they did this doesn't absolve them of responsibility for violating what I think are the fundamental principles when it comes to provision of discovery and keeping that information close to the chest for the purposes of your defense, which you can do vigorously, but not in the public domain.
You're listening to the Devil's Advocates radio show. Our fine guest, the ever gracious James Santelle. Counselor, I guarantee I didn't ask any of those thoughtful or intelligent questions you attribute to me, sir. The Jenna Ellis, not going to leave. We talked about intent. Jim, when we come back, I want you to give me more thought about how this demonstrates the intent of Donald Trump, and the fact that it's Dan Scavino. It's not really direct evidence. It's hearsay evidence, right? I'd like you to talk about the admissibility of this specific piece of evidence that I've now played for the audience. We did it yesterday. We called them the Kraken tapes, but the Jenna Ellis tape is really quite a bit more interesting. Kind of like
we'll talk about that.
Than me.
And we'll talk about hearsay too, right after the break, I assume.
And you'll give me credit for more great questions that
Absolutely.
I hardly even have to ask. More Devil's Advocates.
And we're back. Thank you for listening to the Devil's Advocates radio show. Make sure you download the Civic Media app. You can go to civicmedia.us. You can also find the Devil's Advocates there for podcasts and interviews.
Dom, we got a fine guest. He's stuck around. He's the host of the Morning Cannoli on the Saturday mornings right here on the Civic Media Radio Network, 9 to 11 a.m. Jim, appreciate you sticking around. Intent. The Jenna Ellis tape, it was leaked to the public, and, the squabbling over whether or not it should, that's someone else's problem. I'm glad it was, Jim, because it demonstrates the intent of the boss. And everybody knows the boss was Trump, and everybody now knows the boss had no intent of vacating the White House. They just weren't going to leave. You and what army, right? And she said, but that's not how it works. He said, I paraphrase, but effectively, now it does.
We don't care.
We don't care. Jim, your thoughts about what you've, I'm sure, heard on the greatest radio show ever, and perhaps in other media outlets.
Principally through the wonderful broadcasts, including this one of Civic Media, of course. Two things, and you hit on both of them. One is, why is this important? And then we'll do a little law school stuff too, which we often do here on Devil's Advocates, right? The reason is, as you just subtly or perhaps implicitly indicated, what is the intent? If Donald Trump honestly, genuinely believed, which is what his lawyers are sort of advocating or indicating will be his defense, that he genuinely believed the election had been stolen and that this was not about any intent to undermine the process of voting, the counting of the electoral votes on January 6th, those kinds of things, then he doesn't have a good defense, but at least it's arguably within the ambit of something you would argue to a jury. Here, that what Jenna Ellis and presumably others are saying is we told him expressly that he had lost, and he told us effectively that doesn't matter. That's not my consideration. He wasn't fighting with them about what he'd lost or not. He was basically saying, I am staying in power. It is not at all about my vindication of some justice related or democracy related issue having to do with the future of our republic. It's all about me. And that goes to the intent. That's why it's such a damning piece of evidence. Presumably she'll testify about that during the trial. And here's the law school part of this. And it's the other piece that I suspect people will revel in. Yes, this is Jenna Ellis, who is there in the room talking directly to the defendant, which is the key here. She is now a cooperating witness. She will take the stand and she will say, that person, Donald Trump, who's sitting right there at counsel table, told me these things. You may say, well, gee, that's hearsay. How does that come in? The answer is it does come in. It is not hearsay, believe it or not, because under the rules, you're talking about statements attributed to a party opponent. This is the defendant whose words are coming out of this other person. And you can describe it, if you will, colloquially as an exception to the hearsay principle. It comes in, and everybody knows that. And that's why this particular rendition from Jenna Ellis, and presumably others, will be a part of the trial whenever it happens in Georgia. Another topic. But it will come in, and it is completely inculpating when it comes to that intent issue. This is not good news for Donald Trump at all.
Funny Willis says this trial will not end before the election. She says it will drag into 2025. Our understanding, Lena Habas, the attorney for Trump, the Eileen Cannon, she's giving every indication she might be in the tank for Trump. So I have less confidence that that trial's going forward, and that probably offers the clearest evidence. I mean, he's seemingly so guilty of this. We've seen the photos, Jim.
Right.
But the Jack Smith, the J6, the crimes perhaps alleged and perhaps soon to be proven against the former president. I'm putting all my hope in this trial because this is the big enchilada, Jim. This is the underlying crime as far as I'm concerned. The evidence we've seen, the Jenna Ellis tape, does Jack Smith get to utilize this evidence as well or call her as a witness? And do you expect he will?
Right. And that is the question here. Again, this is just speculation. The reality is that, again, the so-called the insurrection trial, the January 6th, the voting trial, scheduled to go in the District of Columbia in March, just as the election, the campaign is ramping up at the same period of time. Interestingly, almost the same time as the New York hush money case in Manhattan is also scheduled. So lots of things happening in March of this coming year. But absolutely, the law enforcement can and does routinely share evidence. Would be interesting to know, and we've talked about this before on this very good broadcast, whether or not, and I assume they are, that the attorneys who are representing the Jenna Ellises and the Ken Chesbros and the Sidney Powells and the Scott Halls of the world have also got to be chatting, I assume, with the federal authorities. And I was actually sort of surprised that they cut a deal on the state system and the state prosecution without wrapping up something there. Now, they're not charged. They're not charged in the federal case. And Jack Smith has some discretion there, but presumably, at least some of those folks we know are on the list of the unindicted co-conspirators in that case going to trial in March, the January 6th federal case. And so highly likely that there is some communication among the attorneys there, including the investigators and the prosecutors themselves. They don't have to coordinate amongst each other, especially since we've got a federal case and a state case. Some of them indicated even that we know each other. We talk from time to time, but we're not coordinating. They don't have to do that, but nothing prevents them from sharing that sort of thing. And there may be some agreements about the uses to which some of these tapes, these recordings are provided. But you have to believe, once again, that Jack Smith, even though he is equally outraged by the release of these tapes into the public domain, is also recording all of them and can, in fact, in that trial, in the January 6th trial in the federal court, he can call these witnesses himself and also elicit from them the testimony that they're also providing now in the state system. whether that's a cooperation situation, whether that is compelled testimony. They could also, of course, invoke the Fifth Amendment. Curious because they're already waiving their Fifth Amendment in the state case. Lots and lots of issues here. The short answer is yes, this can be a part of a federal presentation too, as well as the state case going ahead at some time later this year and into 2025. I agree with you. The January 6th one coming up sooner. Donald Trump, the singular defendant, 4 counts in that case. We're focusing on him and his conduct. We don't have to deal with other defendants in that case. It's just that focus on what he did and those 4 very, very compelling counts set forth in that very, very compelling talking indictment that we've also chatted about in the past.
James Santelle, former U.S. attorney, last 30 seconds. Nevada, Arizona, Michigan,
Yes.
Georgia investigating the fraudulent electors. What's going on in Wisconsin, sir?
As far as we know, our Attorney General continues to say, I will neither confirm nor deny the existence of an investigation. That's the last I heard. Disappointing. He can actually provide that information because it's a matter of public interest, the otherwise principle that attaches there. We will look forward, and we've talked about this on this show, on the Saturday morning broadcast. There's a statutory basis in Wisconsin to do it. He's got the authority to do it. He's got the facts to do it here. He should follow Nevada. We should follow those other jurisdictions that have similarly charged or at least investigating the fake electors in their states.
You fine people should follow Jim Santelle on the morning cannoli, Saturday mornings 9 to 11, right here on WMDX, WAUK, The Shaw. Jim, thanks for coming around, my friend.
Thanks, Jim.
Always a great pleasure, gentlemen. Have a good Thursday afternoon.
Thank you for Devil's Advocates. The rest of you, stick around. 844-967-2789. Time for your calls.